Good day, Internet. This is Chavez and Valko, the key to your immigration solutions. I am Senior Associate Ben Hamilton, and we are here to talk about all things employment-based immigration. And today, actually, we're going to take a cue from one of our viewers who had a question about changing employers. So today, we're going to talk specifically about changing employers. This is something that I know throughout our videos has come up and we've mentioned, but hey, it was a good question. We thought it'd be a good idea to take all of these different little things, bring them into one video, so anyone who is looking to change their employer can get all of the information they need. So to start, we're just going to talk about changing employers generally for a petition-based case. What do I mean by petition-based? There's certain cases that require you get pre-approval from USCIS no matter what you do. So for example, those can be like H's, R's, O's, L's, unless it's a blanket, right? And then there's the non-petition based, which are like TNs and E's, where you can just go and apply directly for the visa without having to go through USCIS first, right? So when you're talking about a petition-based visa, again, looking at like H's, for example, you always have to file a change of employer with USCIS, right? So your new employer files a change of employer. There's a box they check for that. And usually they request also an extension of status to go along with it, right? So they can get the max validity period for them. Even if you like just gotten approval with employer A and it's for 3 years, right? Employer B wants to get the max approval with them, right? The full 3 years if you're an H. Now, there is what we know as a grace period, right? So the question always is, well, what if I got fired? What if I quit? What if I got laid off? Especially now that the economy seems to be, slowing down a little bit and people are worried about layoffs. What are my options for filing a change of employer? Well, there is a 60-day grace period for most non-immigrant visa categories. So from the day you get laid off, is if you can find a new employer and that employer file a change of employer within that 60 days, you can stay in the US and you don't have to leave. Of course, the question is, well, when can I start working? In most cases, you cannot start working until the change of employer has been approved by USCIS. We'll talk about an exception to that in a little bit. So in general, you have to file a change of employer. You're either filing it while you're still employed with employer A, right? And then, of course, you give like notice once it's approved. Or maybe you've been laid off or quit. In that case, you have 60 days. Now, let's say, well, what if I don't find an employer within 60 days? Well, obviously, if you stay past 60 days, you've overstayed, right? That's bad. You begin accruing unlawful presence, and you're going to get in trouble. Alternatively, obviously, what you can do is just leave the country. Because again, if you're looking at a petition-based case like an O or an H or an R, the new employer can still file the case. They can still file an O and just request consular notification, right? Meaning once it's approved, it doesn't come with a 994, doesn't come with status because you're not here. What happens is you take that approval notice, you apply for the visa, and you come back, right? So really two options here. You file it while you're still employed or within the grace period. You can just do it as a change of employer. You don't need to go anywhere. Or you leave, they file it via consular notification, and you come back, right? Again, we see a lot of cases, especially, I don't know why, with TN visas in particular, where people are just like, well, I got my TN, I can go work for anybody, right? And it's like, no, right? Most of the time, the approval you have is employer specific. Now, here's just a weird little caveat we have to throw out there. The visa stamped in your passport is not employer specific. And you're like, well, wait a second. There's an annotation down at the bottom and it has the name of my employer. How is this not employer specific? Well, let's say like a petition-based case like an H. The approval notice is employer specific and you have to have that approval notice. But then when you use that approval notice to go get the visa, that visa is actually not employer specific and can be used with a subsequent approval notice. So if I get an H-1B visa approved for 3 years, I file a change of employer, it gets approved. I can actually use that new approval notice with the old visa as long as it's still valid. So that's kind of a nice little thing there, that you don't actually have to renew your visa after every change of employer in most cases, we're going to talk about the exception to that too. All right. So one interesting thing to talk about, the H-1B specifically, right? The H-1B specifically. When you file a change of employer, if you're in the United States, you can actually start working for the new employer upon receipt. You don't have to wait for the approval. This is just a weird caveat, carve out for H-1Bs. Now, most people obviously don't like to do that because what if I leave employer A, they withdraw my existing approval notice, I go to employer B on receipt, and then it gets denied, right? Then you're left with nothing. So that's why most people choose to not actually move to employer B until it's approved, right? But legally, you can move upon receipt. Now, another question is, well, what if I leave employer A, I go to employer B upon receipt, my case for employer B gets denied, but employer A never rescinded or withdrew the LCA and the approval notice? Well, technically, that LCA and approval notice is still valid, and you can go back to employer A, right, as long as it hasn't expired. Sometimes that happens, right? I've seen employers that are just kind of like, you might come back, so I'll just leave this open. Of course, there's other employers that just immediately revoke it or withdraw it the second that you leave. So again, the H-1B has this weird caveat where you can actually start working upon receipt as opposed to approval. Another one you have to watch out for, right, is that cap exempt versus non-cap exempt. So if I got my original H-1B working for a cap exempt employer, meaning I didn't have to go through the lottery because they're like an institution of higher learning or affiliated with an institution of higher learning or research, and then you again, like this would be like a university, and then now I'm got a job in the private sector. Well, guess what? In order to go from cap exempt to cap subject, you have to go through the lottery, even though you had an H-1B, right? So you're going to have to plan, oh, wait, they got to register me in March, so I probably got to stick with employer A all the way through the process, right? All the way through September, right? Until that H-1B with employer B actually kicks in on October 1st. It becomes a little bit tricky in terms of how to manage that. So again, circling back, any petition-based visa, you need to file a change of employer, whether you're here, or file a case, request consular notification. If you're not here, you have a 60-day grace period. H's have the little caveat where you can start on receipt as opposed to approval. And then always remember the going from cap exempt to cap subject can be tricky. Talk a little bit about the non-petition based ones, which are the TNs and the Es, meaning for a TN, I don't need to seek any pre-approval from USCIS. I can just go apply directly at the border if I'm Canadian, or I can directly go and apply for the visa if I'm Mexican. Same thing for the Es, right? You can go and just directly apply for the visa at the U.S. Embassy or consulate, depending on where you're from. So they are not petition-based. In this case, the visa stamp is employer specific, right? Because it's not like, oh, I got an approval and then I just got the visa, and right? In this case, the visa is your approval, so it is employer specific. So I can't get a TN with employer A and then just go change to employer B, right? I would have to, go out and reapply for the visa or come back. Now, there's kind of a tricky way to get around that. For example, if you're a TN and you're in the United States and you file a change of employer with USCIS and you get that actual approval notice, then just like the petition-based visas, you could use that pre-existing visa stamp, right, to essentially go out and come back, right? But it's only in the case where you actually file a change of employer with USCIS and get that approval. And then you can use that TN or E-visa like a petition-based case, right? Otherwise, if you're just like, well, I got my TN visa, I'm just going to switch employers. Like, well, no. Like, if you applied for the visa at the consulate, you got to go out and apply at the consulate and get a new visa. Same thing if you're Canadian, you would have to go out and then come back in through a port of entry. And show all the documents related to the new employer. Again, unless before you left, you filed the change of employer and you actually have the approval notice. So again, I don't know why this always comes up in TNs where people are just like, I can just swap employers. No, you can't. You either got to file a change of employer with USCIS or you got to go out, get a new visa or new status and come back in. Now, of course, a big question that tends to come up is revolving around the green card process. Well, what if I'm in the middle of the green card process and I want to change employer? Well, it depends kind of where you're at in this process, right? So there's something called portability, and it's based in a law that we tend to refer to as AC-21. And what it says is that if you have filed your actual application for residency, not your I-140, right? Your I-140 is what your employer files to sponsor you for residency, and then you individually file your application for residency, your I-485. Unfortunately, if you're from India or China, it can be years or decades in between when the I-140 is filed and when the I-485 is filed. But when you file an I-485, the law says that once it's been pending 6 months, you can actually change employers and not have to restart the residency process as long as the new employer is offering you a position that is same or similar to the one, right, that was being sponsored. So let's say I do my labor certification with employer A, it gets approved. They file the I-140, the I-140 gets approved, right? I'm still in this spot where if I now change employers, the new employer has to restart everything, right? The new employer is going to have to do their own labor certification, their own I-140. But let's say I file my 485. Well, once that 485 has been pending 6 months, I can actually change employers, no questions asked. And let's say USCIS sends me a request for evidence, or maybe I get called in for an interview. Well, what do I do? Well, there's what's called a form supplement J, right? So anytime you do an employment-based I-485, you usually include a supplement J, unless it's filed concurrently with the I-140. But anyway, you would just come in with a supplement J from the new employer, right? Just saying this is their name, this is going to be the position, the salary, it's signed by the employer, it's signed by you. It's not a super complicated form. And you just say, oh, here's my new employer. And really the only question they're going to look at is, well, was this pending more than 6 months? And is the position being offered same or similar to the one that was in the original? Easy peasy. Obviously, your biggest risk is processing times actually coming down because historically they've been well over 6 months. And obviously under the Trump administration, they exploded. And then, of course, COVID and all that. It was like you're pretty much guaranteed that your processing was going to be over 6 months. So you could leave your employer. And when I say leave your employer, you don't actually have to wait 6 months, right? In order for them to accept the supplement J, it just has to have been over 6 months since it was filed. You can technically leave before you hit the 6 months if you're confident processing is still going to take over 6 months. But lately, we've had some cases come back that were filed this year and were already approved in 6 months, and we had one in 3 months. Now, I know some people may be watching this and be like, I filed in October 2020 and I'm still waiting. Yeah, I know. USCIS is stupid. When they speed up processing, it only applies to newly filed cases. They do this all the time. It is so frustrating. So there's people that are filed this year getting approved while people that filed 2-3 years ago are still waiting for their residency. We know, like in a specific NATS case with naturalization, I guess they moved a bunch of files to storage during COVID and then they can't get them back. So it's like literally the physical files are stuck over there and they can't get them. And that's why these people aren't being processed. I don't wonder if that's maybe what happened to some of our October 2020 filers. There was that big bubble of filers from India that filed October, November, December 2020. A lot of them are still pending. Actually, I think all of ours are still pending. Again, don't know for a fact if that's the case, but anyway, newly filed cases seem to be getting processed faster. So if it's looking like processing is going to be going to have any chance of being under 6 months, yeah, don't change employers. But again, this is referred to as AC-21 portability. Again, the two main rules here are your adjustment of status has to have been pending for 6 months, and the position offered has to be in the same or similar position. Like I said, if USCIS asks about it, you would just show up with a supplement J from the new employer. And if you're already working for them, you'd have some pay stubs, W-2s, and whatnot. It's a pretty straightforward analysis. If you're at any point before you file the adjustment, again, the new employer would have to restart the process. Now, again, if you're an H-1B in a backlog category, you can still use that old I-140 to file H extensions beyond the cap. You can also use that I-140. You can recapture the priority date of that I-140. So obviously there is a lot of utility to having this old I-140 from a previous employer, if you're like an Indian or Chinese national, but you can't adjust off of it, right? The new employer has to go through the whole process. So changing employers can obviously be tricky. The main thing to know is that basically in all cases, there's something that has to be done, right? You have to file a change of employer with USCIS, or you have to go out and get a new visa or apply for your status in order to do it, right? So as always, consult with an attorney. If you want, consult with us, right? You can go to our website, our socials. You can go online to schedule a consultation, because it's always best to get that opinion, that second opinion, um, to make sure you're doing things right. Right? I've seen too many people kind of try to do it on their own or think they can do something, and then they end up with us staring them in the face and saying, "You're out of status. You're accruing unlawful presence because you did this wrong." Um, so it is really important to make sure you do this right. It is really easy to, mess this up and put your immigration status in jeopardy. Um, but hey, we appreciate the viewer who came to us with a question about changing employers. As always, if you have any questions or comments, leave them down below, including suggestions for future videos. We've already done videos on every non-immigrant visa and on every employment-based immigrant visa category. So that's, residency and work visas. We have videos for all of them, so go look. But if there's any other topics that you're interested in or want us to do a deeper dive on specifically, let us know. Otherwise, again, go to our website. You can schedule a consultation online. As always, download our app, the Lawpilot Guardian. It is free on both Android and iOS with lots of useful information. And thank you for tuning in, and we'll see you guys next time.